I'm here at the Supreme Court where we've seen some incredible scenes today. The Supreme Court, by a majority verdict of 3-2, has struck down triple talaq, or what is known as talaq ibadat, as a valid form of divorce. It is an unconstitutional practice and cannot be used, therefore, anymore by anyone, whether even those from Muslim communities which believe in the practice, to cause a divorce. Now, what we've seen today was some absolute drama in the court because the Chief Justice of India started off the day's proceedings at 10:30 by releasing his judgment, in which he held that the court did not have the right to strike down triple talaq, and that this was not something which the court could do. He did, however, in his judgment, he specified that there would be a 6-month injunction or temporary ban against the usage of triple talaq, and during that 6-month period, the centre had to legislate to remove it if they so wished. Now, what this meant was at that time that it looked that this view was going to be the judgment of the court. Many lawyers, many journalists stepped out to tweet out this news, and that is the news which was initially released. However, in a stunning turn of events, first Justice Quint dissented, stating that no, triple talaq was absolutely invalid in Muslim law as well. After that, Justice Nariman, in a judgment supported by Justice U. Lalit, stated that in fact not only is it violative of Muslim law, it is also violative of the fundamental rights section of the Constitution and therefore unconstitutional. As the confusion was finally sorted, it turned out that 3 judges therefore had held that triple talaq had to be struck down. The fact that it was unconstitutional was the majority verdict. And what that means is that therefore there is no need for any new legislation by the centre to specify that triple talaq is an invalid practice. What that means is that whatever Justice Khehar said in his judgment has been rendered as purely his own personal views and not have any force in law. So, to unpack what that means for our viewers, we will be analysing the full judgment of the court to be absolutely clear what they have said, because there remain certain issues, like for instance what happens to people who have already faced divorce because of triple talaq. Now, that is not clear what the status will be, given that the practice has been held to be unconstitutional. This could technically mean that they no longer that they are actually still married. And this is in fact the view which is being taken by lawyers such as Indra Jaising to apply to what happens to the petitioners who brought this case to the Supreme Court in the first place. However, we cannot be entirely sure of that until and unless we've actually finally read the judgment, which should be out shortly, and we will be analysing it for you. However, the key takeaway is triple talaq has been declared to be unconstitutional and has been struck down. It is not valid anymore. And the Chief Justice of India, in his last week on the job, found himself in a slightly embarrassing situation where his judgment was rendered to be purely his personal views and a minority opinion. To clarify, Justice Kher and Justice Nazir have the minority view that triple talaq cannot be declared to be struck down by the Supreme Court, while Justices Nariman, Quint and U. Lalit have held that it is not valid in law and it therefore needs to be struck down.